Okay? Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case.
You ever see a Senate hearing where things get so intense you almost feel like you're in the hot seat? That's exactly what happened when Senator John Kennedy sat across from a federal judge nominee and hit him with, "Look me in the eye and just answer my question." Let's break down why this moment had everyone talking and what it really says about the way we interpret the Constitution today.
Professor, congratulations. I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it. At the time it was...
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
Okay. So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator,
at the time... But first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
Well, Senator, I don't know as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several fundamental amendments to the...
But isn't that inconsistent with your statement that you have to interpret it according to original public meaning?
Well, what about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean with those... Well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th, all which have...
But do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial equality.
You're not answering my question. I'm trying to understand I'm just trying to understand how you think. It's very easy to say, we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case. So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute
What do you do if it's ambiguous?
If it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
No. I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say I would use the same approach essentially in all cases regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that
Professor,
point...
I'm going to run out of time. With respect, answer my question.
Well,
okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Yeah.
So
why don't you just look at legislative history?
Well, you can't look at legislative history of statements one by one because the individual intent... Well, Senator, with respect, because this body has its role in our system as an institution, not one by one. So your personal understanding of the law doesn't matter.
This will be my last question. I'm sorry. Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
Thank you, Madam Chair.
Thank you.
So, here's the setup. The nominee's on the stand, and Kennedy asks him straight up, should judges read the Constitution according to its original public meaning? Now that's legal lingo for, should we interpret the Constitution the way people understood it when it was written, or should we adapt it to fit modern life? The nominee says, yes, he's an originalist, meaning he wants to go back to what the words meant back then, but Senator Kennedy isn't letting him off that easy. Kennedy brings up Brown v. Board of Education, the Supreme Court case that ended racial segregation in schools. He asks, if you stick to the original public meaning, was Brown actually decided right? The nominee says, absolutely, Brown was right, but Kennedy keeps pushing. Did Americans back then support integration? The nominee admits, no, most didn't. But here's where it gets interesting. The nominee argues the Constitution changed after the Civil War. When the 13th, 14th, and 15th Amendments were added, they put racial equality straight into the text. So, you can't just go by what people thought in the 1700s. You have to look at what those amendments meant in their own time, and the 14th Amendment. It's all about equal protection under the law. So, when later evidence showed that separate but equal actually wasn't equal at all, Brown v. Board fit with the spirit and the letter of those amendments. That's how an originalist can say Brown was right, even if most folks in 1868 weren't thinking about integrated schools. Kennedy's not done. He moves on to how judges should handle ambiguous laws. The nominee's approach? Start with the text. Then, look at the law around it. If there's still confusion, check the context. But ambiguity isn't an excuse to punt. Judges have to actually interpret and decide. Then comes legislative history. Think committee reports, floor speeches, all that jazz. The nominee says, yeah, it helps with context, but it's not the law. Congress acts as a whole, not through one person's speech. So, legislative history is a tool, not a trump card. By now, you can see why this exchange is about way more than legal theory. It's about how we confront our country's past, how we apply old words to new problems, and how the law evolves without losing its soul. Senator Kennedy's grilling style? It's dramatic, sure, but the real drama is in the stakes, because these decisions shape real lives. If you want more clear, no-nonsense breakdowns like this, hit that subscribe button, like the video, and share it with someone who needs to see behind the headlines. More deep dives are coming soon, so don't miss out. Thanks for hanging out with me. See you in the next one.